So let me also welcome all of you, and it's nice to see a lot of familiar faces to the CICL annual lecture. For the first time, this lecture is being co-sponsored by the American Society of International Law's Women in International Law Interest Group, or WILIG. So I'm co-chair of this group, which is composed of over 500 members who are dedicated to promoting and enhancing the careers of women in the field of international law, as well as awareness of gender in all areas of international law. So tonight's remarks are going to be recorded, hopefully, we'll see, and shared with the WILIG network through the website. I also wanted to let you know that starting this academic year, UB has become an academic partner school of the American Society of International Law. And the American Society, or ASIL for short, is a nonprofit, nonpartisan educational membership organization that's composed of attorneys, academics, corporate counsel, judges, representatives of governments and non-governmental organizations, civil servants, students, and others interested in international law. Because of our new status as an academic partner school of ASIL, there are new resources that are available to our community, to faculty, staff, and students, including ASIL's job board, career counseling, WILIG's mentoring program, and discounted memberships, and reduced fees for attending events for students, staff, and faculty. I also wanted to let you know about an event that the International Law Society and the LCDO will be putting on November 20th, I believe it is, on how to get a job in international law. So if you're in ILS, could you raise your hand? Okay, so you can reach out to any of those people to learn more about that program. And I encourage you to learn more about it, to join ILS, and to attend that event if you're interested in exploring a career in international law. Now I'm very happy to welcome and to introduce you to our distinguished speaker for today, Dean Monica Pinto. Dean Pinto is a renowned international law academic and international lawyer with diverse experiences and wide-ranging expertise in the world of international law and human rights. She currently serves as president of the administrative tribunals of the World Bank and the Inter-American Development Bank, and I believe she was doing that just now before she came here to speak to us. She is also a member of the panel of arbitrators at the International Center for Settlement of Investment Disputes and Mercosur. In addition to serving as an arbitrator or judge, she has appeared as counsel before several human rights bodies and tribunals, arbitral tribunals, and the International Court of Justice. I had the honor of serving with her in a case before the International Court of Justice on the obligation to negotiate and watching her in the Peace Palace in action and in French. So it was very impressive. Her contributions to the Chilean team in that case were indispensable, and her arguments were essential to securing the decision in that case. Dean Pinto has also held UN mandates regarding human rights in Guatemala and Chad, and on the independence of judges and lawyers. She's also worked as a public servant in Argentina in a number of different roles, including as Director of Human Rights in the Ministry of Foreign Affairs, Director of Cooperation and International Affairs, Deputy Director of Public Law in the Ministry of Justice. So because all of this clearly wasn't enough to keep her busy, she also had a distinguished and has a distinguished academic career as a professor and former dean of the University of Buenos Aires School of Law, a law school which has 28,000 students, just to give you 22. Well, the website says 28, so maybe there's something going on there. And apparently 1,500 faculty members. So she has taught at the prestigious Hague Academy and universities around the world, including in France, the United States, and Guatemala. And she is a recipient of numerous awards, including the Ordre National du Mérite as a Chevalier by the French Republic, the Goler T. Butcher Medal in 2009, and the Honorary Membership Award in 2019 of the American Society. So I feel very privileged and honored and fortunate to know Dean Pinto and to have gotten to work with her. She's a true inspiration to both women and men in the international law field and beyond. And I know it makes her uncomfortable for me to say that, but it's true, so I'm going to say it anyway. So please join me in welcoming her to the University of Baltimore School of Law.
Everybody, thank you very much. After such an introduction, all the expectation, the threshold is so high that I don't know whether I will be able to satisfy your aspirations or your hopes. I really thank you very much, Professor Grossman, Ninke, for this invitation. And it was really a privilege to work with her, and I assume you'll find her classes very interesting and very inspiring too. Today, the subject I proposed and we debated deals with human rights, with women's human rights, and especially with women's human rights standards in the inter-American system. You know, the states are part of the inter-American system, even though the United States has not ratified the American Convention. But in any case, this inter-American system has been very active in framing women's human rights. And that's what I propose you to visit with me this afternoon. I'll try to make it in a reasonable amount of time. At the very beginning, human rights were framed in rules drafted with the universal approach. You could read, all human beings have the right, everyone is entitled to, no one shall be subjected to. And these rules were deemed to be useful and to protect the human rights of all human beings, elder and children, here and there. However, soon after the starting point of human rights, it was realized that these universal formula were not so universal in everyday life and in many parts of the world and for many human beings. A specific protection approach was conceived in order to deal with the situation of some human beings who all over the world suffered from the non-recognition of their human rights. In November 1967, the United Nations General Assembly expressed its concern regarding the considerable discrimination against women that continued to exist and declared itself convinced that the full and complete development of a country, the welfare of the world, and the cause of peace required the maximum participation of women as well as of men in all fields. It then adopted a declaration on the elimination of discrimination against women. On those grounds, some years later, in 1979, the Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW Convention, was adopted. The CEDAW Convention is the major international legal instrument regarding women's human rights. It embodies all existing human rights as women's rights and provides for states' obligations regarding every right, provides for the adoption by states of temporary special measures aimed at accelerating the de facto equality between men and women, and includes relevant obligations for states from a cultural point of view. The Convention requires, for instance, the modification of social and cultural patterns of conduct based on the idea of the inferiority or superiority of either of the sexes, or on stereotyped roles for men and women. It also ensures that family education includes a proper understanding of maternity as a social function and the recognition of the common responsibility of men and women in the upbringing and development of their children. In the specific context of the Inter-American system, the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, the so-called Convention of Belém do Pará, was adopted in 1994. This instrument, together with the CEDAW Convention, completes the specific protection of women's human rights in the Americas. It embodies states' duties to prevent, punish, and eradicate violence against women and provides for a specific system of complaints to be lodged with the Inter-American Commission on Human Rights. The practice of all the universal bodies, the so-called treaty bodies that are established in the 9 core human rights conventions, and the practice of both the Commission and the Court of the Inter-American system has produced decisions on specific cases and also more general statements on the scope of protected rights. And from those decisions and statements, some standards can be inferred. Those standards are very much useful when you have to go for the interpretation of women's rights in specific situations. Of course, they don't prevent the occurrence of new rules, the emergence of new rules and better interpretations. But in any case, they are there and they ensure a certain level of protection of women's rights. So let's start the journey through the Inter-American System on Human Rights standards. I will be dealing with 3 standards that are contextual, if you want. I don't like to call them procedural, but contextual, and then I will be dealing with the specific rights. The first standard I will be dealing with is that regarding the interpretation of women's human rights. According to the Inter-American System, women's human rights in the Americas consider all international rules in force, universal and regional, and they have to be brought in the light of the pro persona principle. The pro persona principle, some years ago, it was called the pro homine principle. The pro persona principle is an hermeneutic principle, an hermeneutic interpretation tool that helps to find the broader interpretation on the scope of rights and the more restrictive interpretation on the permitted restrictions. And according to that, both the CEDAW Convention and the Convention of Belém do Pará, and I will be quoting the Inter-American Court, are considered to complement the international corpus juris in matters of protection of women's rights to humane treatment, of which the American Convention forms part. What did the court do in this situation? It just followed a precedent. Technically, it's not a precedent, but you can identify it like that it has itself adopted when dealing with the street children in the case against Guatemala in the late 90s. There, in order to implement the line and a half of the American Convention saying that every child has the right to be protected because he or she is a child, the court seized the International Convention on the Rights of the Child, which had been ratified by all the member states of the Americas that were in his case, and it said, well, this international convention will complement this line, this very broad mandate regarding children's rights in the American Convention. So here it does the same. It just takes the same path, the same way, and it's very interesting because this is a very positive way of just having together and avoiding fragmentation and other phantoms and ghosts that are there when dealing with international law, is a very positive way of integration of regional and universal rules. The second standard is regards discrimination against women, and that standard says or proposes that discrimination is structural. It's a question of structures and not of given situations. As you know, equality is one of the most revolutionary features of the notion of human rights. The notion of human rights brings equality to the forefront of the individual rights, if you want. And for the first time, it says, no matter who you are, where you are, and how you are, you have the same rights. You are entitled to the same rights than your colleague, the one in front of you, and that one who looks completely different from you. This feature of equality cannot be reduced to a formal category when dealing with women. Why? Because discrimination against women doesn't raise issues regarding a given woman in a given situation. Discrimination against women considers the whole group of women, and it takes into account some views of the society on the very specific situation of women in it. They consider the subordinate role of women in society and how family relationships take place. And at the end of the day, that discrimination considers and has taken note that generally women do not claim for their rights. So this feature has led those working in the field of women's human rights to the conclusion that, in fact, dealing with one case and not considering the whole universe of women in the same situation is completely useless. So here you have to take into consideration the context, because the context matters. What the context provides you is important. And this has been accepted by people dealing with constitutional rights in the States, like Owen Fees in Yale Law School, or more specialized people dealing with human rights, like Catherine McKinnon in Columbia Law School. Cathy McKinnon has a very specific statement saying, the social position of women plays a relevant role when you are analyzing inequality. So the system had to deal with this structural inequality. And it did so in a very important case of the Inter-American Court, the Cotton Field case. The case concerned or regard the disappearances and murder of 3 young women in Ciudad Juárez in Mexico, just in front of Texas. And in order to deal with the case, the court had to consider the high number of women, including girls, the great majority of them poor women, the great majority of them working in the maquilas, in the garment sector in the region. Some of them were migrants. There were also some students, and all of them had been victims of some kind of facts that included, and I'm quoting, murders and disappearances. And the court said those murders were gender-based and were perpetrated in an acknowledged context of violence against women in Ciudad Juárez. One of my colleagues at the University of Buenos Aires, a former member of the Inter-American Commission, Victor Abramovich, suggested that when the court was examining the situation of these 3 women, it considered them as members of a larger group affected by a structural situation of violence and inequality. And in order to do that, the court conducted, if you want, some in-depth analysis of Article 7 of the Convention of Belém do Pará, the Convention Against Violence. And here comes my third contextual standard. There is an enhanced obligation of due diligence in cases of structural violence and discrimination. That case of the cotton field, it's called like that because the corpses of the 3 girls were found in a cotton field. The case of the cotton field dealt with, and I'm quoting, the lack of measures for the protection of the victims, 2 of whom were minor, the lack of prevention of these crimes in spite of full awareness of the existence of a pattern of gender-related violence that had resulted in hundreds of women and girls murdered, the lack of response of the authorities to the disappearance, the lack of due diligence in the investigation of the homicides, as well as the denial of justice and the lack of an adequate reparation. The court, as I told you, conducted an in-depth analysis of Article 7 of the Convention of Belém do Pará, and the court came to the conclusion that states should adopt comprehensive measures to comply with the due diligence in cases of violence against women. In particular, they should have an appropriate legal framework for protection that is enforced effectively and prevention policies and practices that allow effective measures to be taken in response to the respective complaints. The prevention strategy should also be comprehensive. In the words of the court, in cases of violence against women, the states also have the general obligation established in the American Convention to protect, to ensure the exercise of protected rights in the system, and also the obligation to adopt measures. So states also have the general obligation established in the American Convention, an obligation reinforced, enhanced, since the Convention of Belém do Pará came into force. The court also considered that the government of Mexico was aware of the situation of risk in which the women were. Why? Because Mexico has a National Commission on Human Rights, and that commission had warned the government of the situation. It has issued more than one resolution and recommendation calling for the adoption of measures. So the court said the government was aware. It had an obligation, an enhanced obligation, and in fact, it did not show to have taken the appropriate measures. The court also considered that what the case dealt with acts by non-state actors. The court was aware that this was not a case of a public official going with a gun and just murdering. These are cases in which non-state actors have a relevant role. And of course, the state is not responsible for whoever does in the public field. But the fact that the state or the government was aware of the risk situation in which the women were, I will read perhaps, of its awareness of a situation of real and imminent danger for a specific individual or group of individuals, and the reasonably possibility of preventing or avoiding that danger. That was what the government failed to do. It didn't adopt any measures to prevent or avoid the danger. So, summing up, in order to give an interpretation of women's rights, you may take universal and regional rules and you put all together under the standard of the pro persona. The broadest interpretation should prevail, and the restricted interpretation of permitted restrictions should prevail as well. When you are considering violence and discrimination, you should be aware of the context. There are things, the context speaks. The context provides elements. So this is a structural inequality or discrimination. And whenever this is in a structural situation and there is some risk, the state has not only the ordinary obligations under the treaties in force, but also an enhanced obligation to be efficient, to be effective. Let's start with the specific rights. My first standard will deal with domestic violence, the right to be free from domestic violence. And in this field, the system, the regional system has, on the one side, an article in the Convention of Belém do Pará, an article that says that violence against women shall be understood to include physical, sexual, and psychological violence that occurs within the family or a domestic unit or within any other interpersonal relationship that occurs in the community and that is perpetrated or condoned by the state or its agents, regardless of where it occurs. Because you know that violence is normally in the bedroom, near the bed, in the dining room, there is violence. So, the Convention not only defines violence against women, it also protects the rights of women in different articles and also provides for these due diligence obligations. The leading case is a case that was considered by the Commission, not the court, is a case of Maria da Penha Maya Fernandes. It's a case against Brazil, a case that started when Brazil had not yet recovered democracy in the last years, and was concluded while there was a democratic government in Brazil. The case is the best checklist of all the stereotypes and prejudices that you can put over the table concerning cases of gender and violence. Maria da Penha and her husband were both high middle class in Brazil. They had university degrees, both of them. He was very aggressive, and he was all the time just very aggressive with her, but she was very much reluctant to denounce him. Once she decided to do so, and she started facing the neglect, the negligence, the disregard of the police and of the prosecutors that told her, go home, he loves you, is a way of. But one day, he went too far, and Maria was sent to hospital, and she was left paraplegic. Maria had the assistance of an NGO dealing with women's rights, CLADEM, and one of the psychologists there suggested her, because it was a very traumatic situation, whether she wanted to tell. And a journalist helped her, and they produced a book, Sobreviví e posso contar. I survived, and I can tell you what I experienced. And because of that, the case was brought against the government to the commission. The government kept silent. Not even a word of explanation of what had happened. Of course, they were not in Maria's house, but they could have said something about the attitude of prosecutors and police and so forth. So, complete silence. The Commission, in its report, underlined, and I'm quoting, the impunity that the ex-husband of Mrs. Fernandez has enjoyed and continues to enjoy is at odds with the international commitment voluntarily assumed by the state when it ratified the Convention of Belém do Pará. The failure to prosecute and convict the perpetrator under these circumstances is an indication that the state condones the violence suffered by Maria da Penha. And this failure by the Brazilian courts to take action is exacerbating the direct consequences of the aggression by her ex-husband. Furthermore, but as had been demonstrated earlier in the report, that tolerance by the state organs is not limited to this case. Rather, it is a pattern. The condoning of the situation by the entire system only serves to perpetuate the psychological, social, and historical roots and factors that sustain and encourage violence against women in Brazil. After that, as it's usual in the inter-American system, there was room for the proposal of a friendly settlement. Friendly settlement is not a situation in which a state can negotiate in order to escape accountability. Rather, it's a possibility for the victim and the representatives of the government to reach an agreement on how the non-repetition measures or guarantees will be given. And in this case, they decided that legislation regarding violence against women had to be adopted in the country. It had to have federal level for everybody to be bound by the same legislation. And that happened the 7 August 2008, more than 7 years after the main facts. And of course, the act is known as Maria da Penha's Act, and now Brazil has started to put all his cases regarding violence against women in that framework. Of course, at the universal level, there is also the mirror case of Maria da Peña, which is the case of Mrs. A.T. versus Hungary, which was decided in 2005 by the CEDAW Committee. My second standard will deal with sexual violence. And here I will be dealing with cases, different cases. On the one hand, cases in which public officials commit rape against women, mainly in situations of counterinsurgency, as in Peru in the 90s, for instance. Also, cases in which public officials just go straight and rape women that they are guarding. The system benefited from the statements of both the UN Special Rapporteur on torture and the UN Special Rapporteur on elimination on this, the UN Special Rapporteurs on violence against women. Both of them had remarked that, in fact, rape was a sort of a tool in the hands of those fighting in counterinsurgents context, in armored conflicts, in internal armored conflicts. Also, but later, the international criminal tribunals had to deal with rape, both as a crime against humanity and as a war crime. So let's see how the system envisages it. The first standard is that rape may amount to torture. And the leading case here is also another case by the Commission, a case that was decided in 1996. It's the case of Raquel Mejía de Martí. Raquel was married, and both her and her husband had been accused of being members of the Tupac Amaru revolutionary movement in Peru. And so the military forces came to their house, and they just took her husband, and they together with them. They told him that if ever she behaved well, he would be back soon. The fact is that he was tortured and immediately murdered. And after a while, the same people who visited the house in order to take Fernando came back and told her, well, we are here because we want your cooperation. If ever you behave well, your husband will be back, and he will be back soon. And so they started putting question, and of course, at the end of that, they raped her, and of course, she defended herself, but she couldn't go a step further because in the other rooms of the same house, her kids were there. When the case was considered by the Commission decided that, in fact, it had to test whether rape amounted to torture. And so the Commission borrowed from the Inter-American Convention Against Torture the elements of torture. And according to that text, is an international treaty of 1987, in order to have the torture, there should be three elements combined. You need an intentional act. through which physical, mental, psychological suffering is inflicted to a person. That act should be intentional with a purpose, and it has to be committed by a public official. So, regarding the first element, whether it was an intentional act committed with the purpose of producing physical, mental pain and suffering, the court considered the elements and said, listen, in this community, the criminal code of Peru just has the same three elements. So it is well known by everybody that when you are committing this sort of behavior, you are incurring in torture. On the other side, the Commission just underlined the trauma that results after a person is raped, and not only because of the physical invasion, but also the moral trauma, and a step further, the suffering that results from the condemnation of the people that is just around the victim. So the Commission said, okay, the first element is satisfied, is checked in the case of. Coming to the second, it said, okay, it must have been committed intentionally and with a purpose. And of course, the purpose of the armed forces when raping Raquel was to humiliate her, just to put her in a situation in which she would have no force to say whatever or to do whatever. And this humiliation was stressed in the dialogue that the members of the armed force had with her. And the third element is that the act has to be perpetrated by public officials. And in fact, the man who raped her didn't come alone. He was there with just 4 or 5 others, all wearing uniforms So the Commission reached the conclusion that, in fact, she had been subjected to torture according to the definition of torture in the Inter-American system. Of course, we can say, but you told us a moment ago that you have to put in place the elements of this structural violence, and here we don't have the language. And that is true. In the 90s, the Commission was not using this language, didn't refer to structural situation. But in fact, when the Commission was dealing with the case, it was taking into consideration first that normally women do not denounce the situation because they are ashamed. They try to avoid condemnation by the near community, the community that is around them. And of course, they also are frightened because of the reprisals that can be taken against the members of their family. So it is basically the same. The language is not updated using the expression of structural discrimination or structural violence, but the Commission was dealing with the same. This pattern was confirmed by the court many years after that in the case of Valentina, Mrs. Rosendo Cantu, a case that was decided in 2010. And I found that these decisions by the Inter-American system are very important. However, one of my points is that the Commission and the court, even though they went far in their consideration of the situation, they couldn't get rid of the element of consent. Consent always bothers women in cases of violence. Why? Because there are some judges in some jurisdiction that says, well, but she consented. Then it was not rape. They are adults. This is a sexual relationship, and she consented. And in fact, consent is not a good ally. We have to put consent in its box, close it, and leave it for a better moment. Consent is important when we are dealing with our sexual rights. But when we are dealing with rape, consent has no place. So I think that here, the good message has to be borrowed from the International Criminal Tribunal for Rwanda, that was established after the International Criminal Tribunal for the former Yugoslavia. Good that we had that before, because if not, we would have never had the Tribunal for Rwanda. And that tribunal did a good job. And when analyzing situations in Rwanda in which all women, elder and younger, babies, all women had been raped, the prosecutor decided that, in fact, okay, you have all the description of rape, the penetration, blah, 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 and they took into consideration an expression that says, under coercive circumstances. And I think when you take into consideration the coercive circumstances, your consent has no place. So, we are consenting? Okay, sexual relationship, no problem. We are under coercive circumstances, that's rape. But let's put them each in its box, because it's not the same. We can also deal with rape as a gender crime when committed by non-state actors. Here, the leading case is not an inter-American case, so I will skip it, and if so, we deal with it after in the. I would like to have my last 10 minutes with a couple of standards regarding, on the one side, sexual and reproductive rights, including perhaps the fertilization treatments and the termination of pregnancy, just jumping a little bit. The first standard regarding sexual and reproductive rights is that points out women's autonomy. Women are autonomous regarding their sexuality. And you can read then that in many international law rules, in the rules of the CEDAW Convention, in the rules of the Protocol of the American Convention dealing with economic, social, and cultural rights, in the rights embodied and protected in the International Covenant on Economic, Cultural, and Social Rights, and also in some important documents that have been adopted by the Caucus of Women, together with governments like the Beijing Declaration in 1995. You were not an idea in your parents' life in 1995, but at that time, the world gathered in Beijing for a World Conference on Women's Human Rights. And the Beijing Declaration and Platform for Action says that the human rights of women include their right to have control over and decide freely and responsibly on matters related to their sexuality, including sexual and reproductive rights and health, free of coercion, discrimination, and violence. And there are also big detail in the explanation of health, and also the aspects regarding the decision on how many kids, when, and how. What did we do in the inter-American system? Well, one of the first standards is taken from a context in which some governments, especially one, decided to intervene in family planning. And this intervention in family planning was towards poor women, women with low levels of education. And here you see how education is important in order to be aware of your rights. And women living in rural areas, women with lots of kids. And the leading case is the case of a Peruvian woman in the time of Fujimori, Maria Mamerita Mestanza Chavez. I apologize for the names, because for those who speak in English, these names I'm bringing to you are too much Latin American, but we can provide you with a good wording. Maria Mamerita was married to Jacinto, and they had 7 kids. And they had been harassed by those social workers that wanted them to sign a form in which they consented for the family planning, and they were all the time avoiding that signature. When she comes to hospital because she's pregnant and she has seventh or eighth kid, she was there with dad, and before getting into surgery, they asked her to sign something, and she does. And she does, as we all do, even with 3 PhDs and the Nobel Prize. When you are in that situation, you sign. And you take no time to read. Once, many years ago, my mom signed, you didn't read. What for? Comma. Okay, you sign. And she signed. She had better luck, bad luck, because she gave birth. She was not feeling well, but in hospital said that that was normal, that she had to be back home, and that will take some days and everything will be okay. She goes back home, and the day after, she died. Some 2 or 3 days after that, a medical doctor from the hospital comes to pay a visit to Jacinto and says, well, we offer an amount of money because we don't know whether you have some claims, et cetera, et cetera. Well, the point is that Jacinto didn't accept the money, and he was there. He wanted to have her wife back, and that was not possible. And so a local organization helped him to bring a claim to the judiciary. Of course, the claim was not successful, and they reached the inter-American system. The complaint went from Jacinto to the government 1 time, 2 times, 3 times, and finally Peru has accepted what is called a friendly settlement, and the friendly settlement was the adoption of a new legislation regarding family planning and other surgery methods regarding family planning. In fact, I realize I haven't told you, but what she underwent in surgery was a tubal ligation surgery, una ligadura de trompas, as we say in Spanish. In fact, the case remained there, and many years later, the court, it was in 2016, the court has to decide a case of a Peruvian woman in Bolivia, IV against Bolivia. And there the court decided to study, to put forward all its criteria regarding informed prior and informed consent. And in fact, well, they say what the doctors have to tell us, but more importantly, they have a special paragraph saying that, in fact, doctors' role is just to advise us, but not to take the decision that we have to take. Your doctor, can you tell what is better, but the decision has to be yours. And I'm sorry, this is one of the cases in which the court has not its own English translation. And you have to know that the Spanish of the court is difficult. All the quoting I've done is because the court has its own English version. But there is a special paragraph in which the court blames the medical doctor, and it says something like, you have had a paternalistic approach towards your patient. And it was not that what you were required to do. You should have been the best advisor of your patient, but it was up to her to decide what to do. The same happened in some in vitro fertilization treatments that the main case is a case against Costa Rica. Again, I apologize for the name of the girl, is Artavia Murillo. Mrs. Artavia wanted to have a kid. She couldn't do so by her own means, and so she decided to undergo in vitro fertilization. And at the very beginning, in Costa Rica, they said it was not possible. Afterwards, because she went to the judiciary, she knocked the door of the judge, and she brought her claim to the system, that was allowed. And the most important part of that is that the court has some important statements regarding the right to privacy on the one side and the right to liberty. You are studying law, and you have to know that whenever we don't have the strict label, we try to broaden some existing right in order to take what we need from that right. And that's what the court does. The court says everyone is entitled to the right to privacy. And the right to privacy includes decisions that are taken in the light of the more important principles in the life of a person. And this is the right to decide whether I want to become a mother, I don't, how many kids I want to have, when and where. And the other one is the decision, the right to liberty. The right to liberty, which is in Article 7 of the American Convention, the right to privacy is in Article 11. And the court says that Article 7 includes a concept of liberty in a broad sense as the ability to do or not to do all what is lawful and permitted. And so it says liberty, thus defined, is a basic human right inherent in the attributes of the person that is evident throughout the American Convention. So Mrs. Murillo could have its baby because of that. And last but not least, important standard regarding the termination of pregnancy. You know that the wording of Article 4 of the American Convention says that the right to life is protected, in general, from the moment of the conception. In fact, what the human rights protect is against the arbitrary deprivation of life. But because life is a natural fact, is a biological fact. But of course, this protection, the right to life is protected, in general, from the moment of conception, has given birth to many interpretations. When the Commission on Human Rights has to deal with that, the Inter-American Commission, very early. It has started receiving complaints on the systematic violation of human rights in our countries in early the 70s. And when the 80s were just there, United States brought a very civilized case regarding abortion. So the Commission could have a break of those tortured, disappeared, summarily executed, and just open the books to study whether abortion was or not, or was not compatible with the American Convention. The case had been brought by an NGO of Catholic physicians, medical doctors, and it was against a woman whose young daughter, had terminated her pregnancy. The pleading of this NGO was that, in fact, the system protected life from the moment of the conception. It has to be taken into account that the U.S. has never ratified the American Convention, and the American Declaration does not have this expression of the protection of life in general from the moment of the conception. However, the Commission tells that to the NGO, but it says, doesn't matter. In fact, if you go back in the history of this Article 4, you'll see that the expression in general between commas was put there because there were some countries in the Americas that already had abortion, US versus Wade, and some countries like mine, Argentina, who has some exceptions to the prohibition of abortion. That is the abortion when it's important for the health of the mother, the abortion when the woman was raped. So there were some possibilities of abortion that were not illegal. So it said, the Commission resumes and says, listen, this formulation in general, between commas, from the moment of conception, was in order to arrange everybody so as all American states could become parties of the American Convention. Of course, accordingly, the Commission decided that the U.S. was not accountable for the abortion in the case of baby. It took a good while until the system came back to the case of abortion. And in fact, it did so in that case of in vitro fertilization. And it takes into consideration the embryos, you say? Embryones? Embryos? Embryos. Thank you for the pronunciation tip. The embryos. And because one of the typical situations when dealing with abortion is that you have someone saying, but you are killing someone because the embryos has protection. And what the court says in Atavia Mauricio is that the embryo cannot be understood to be a person for the purposes of Article 4.1 of the American Convention. Moreover, it can be concluded from the words in general that the protection of the right to life under this provision is not absolute, but rather gradual and incremental according to its development, since it is not an absolute and unconditional obligation, but entails understanding that exceptions in the general rule are admissible. So, what the court proposes is that on this side you have people, human beings. This is not the same in the light of the protection that the system is awarding to the one and to the other. Of course, we can get standards from the CEDAW Committee and the Committee on Human Rights, and we'll see that the general prohibition of abortion is considered to be against a violation of the rights of women from the point of view of the right to your own body, to take your decisions. And at the same time, there are others coming and proposing a completely different interpretation. I will stop here, and I will conclude just saying that, in fact, these standards are very much useful not only for judges, but they should be useful for public officials in administrative instances when you are dealing with situations in places in which you have more than one problem. This is a university, and I had, as Professor Grossman told you, I had to manage a very huge institution. And there we had problems. We had problems like in every university place. And these standards are important, but are not so important for us to teach. Okay, it's fascinating teaching you human rights, and I would like to do so. But they are more useful if you can take them and introduce them in practical measures that will make everyday life for every woman better. Thank you so much. No salió tan largo.